Hello and welcome to ThePrint. This is Khadija Khan from New Delhi, and today we're going to be talking about whether lawyers can be sued for defamatory statements made in court proceedings. The Supreme Court has attempted to answer this very question in a case that relates to senior advocate Vikas Pahwa. A bench of Justices Dipankar Datta and Sandeep Mehta upheld a Delhi High Court ruling given by a two-judge bench which said that on account of the doctrine of absolute privilege, statements made by advocates in judicial proceedings will be protected. In this video, we will first talk about the facts of the case and then move on to understanding what absolute privilege means. In the plea before the top court, a businessman named Pankaj Oswal had challenged the statements made by Pahwa, who was representing the other side during trial court proceedings. Oswal said the statements were defamatory and caused damage to his name and reputation. He said that Pahwa had told the court that mediation was not possible in Oswal's case due to his unparliamentary language and abusive behavior towards the opposite party. As a result, Oswal said that senior advocate Pahwa should be stopped from fabricating and disseminating false and prejudicial information. Citing the doctrine of absolute privilege, which protects statements made in judicial proceedings, the two-judge bench of the Delhi High Court also dismissed Oswal's petition. Now, what is the doctrine of privilege? Does it protect lawyers from defamatory statements made against another person in court? Let us find out. Absolute privilege in defamation cases refers to the fact that in certain circumstances, an individual is immune from liability for defamatory statements, according to the Legal Information Institute at the Cornell Law School in New York. This doctrine applies to statements made in certain contexts or places and is a complete defense in itself. While under US tort law, this privilege extends to judicial officers, attorneys, jurors, witnesses, legal publications, and statements made by parties during trial or in pleadings, the UK also has a Defamation Act which states that reports of court proceedings will be protected by absolute privilege. In Indian law, this doctrine exists as well. It is one of the three defenses to defamation. Defamation includes both civil wrongs and criminal offences. While criminal defamation is covered under Section 499 of the Indian Penal Code and now Section 356 of the Bharatiya Nyaya Sanhita. On the other hand, civil defamation is liable to be punished with monetary compensation and is further divided into two types, libel and slander. Libel refers to defamatory statements published in writing, while slander refers to such statements being made by way of the spoken word. In the present case, the court also said that it's well established that the one who is being accused of defamatory action will have certain defenses available to him. These include truth, fair comment, and privilege. What are the different kinds of defenses against defamation? Now, delving a bit more into the details of these defenses, truth is a complete defense to defamation. However, the one who's claiming this as a defense will also be required to establish that the statement he's making is substantially true. As for the defense of fair comment, the court said this is ordinarily resorted to by publications, journalists, and opinion makers, and it requires courts to examine if the views expressed could have been honestly held by a fair-minded person based on facts which were known at the time when they were expressed. Now, coming to the defense of privilege, which forms the heart of this case, the court said that privilege is of two types, qualified and absolute. Qualified privilege protects defendants from defamatory action only when properly exercised in performing legal or moral duties and is also referred to as conditional privilege. It does not apply to false or untrue statements and is subject to different conditions like whether the defendant was reckless, what his intentions were, etc., etc. On the other hand, the court said that absolute privilege, which applies to the present case, immunizes a defendant no matter how wrongful or motivated the action is. This also contrasts sharply with the defense of truth, fair comment, or qualified privilege, where motive plays a significant role, the court said, adding that absolute privilege seeks to relax the principle of strict liability for certain occasions, such as in public interest and free expression of views on matters of importance that cannot be curtailed for larger welfare. The doctrine also disallows entertaining of claims against judges, lawyers, witnesses, or parties in judicial proceedings, in courts, or tribunals. Apart from this, statements, testimonies, and documents used and prepared for use in judicial proceedings would also be protected by way of this doctrine. The court also pointed to an exception where absolute privilege would not protect someone. It said that statements not uttered for the purposes of judicial proceedings by one who has a duty to make them during these proceedings, or statements having no reference at all to the subject matter of the proceedings, will not be covered under this doctrine. Finally, the court dismissed the petition while holding that the alleged utterances made by the senior advocate, even if assumed to be true, would be protected by the absolute privilege doctrine. The bench also said that as far back as the 19th century, courts have enunciated this principle. Thank you for watching. For more legal updates, stay tuned to ThePrint's YouTube channel. This is Khadija Khan from New Delhi.